Our witnesses on panel 2, first, Mr. Chris Crane currently serves as the president of the National Immigration and Customs Enforcement Council 118, American Federation of Government Employees. He has worked as an immigration enforcement agent for the U.S. Immigration and Customs Enforcement, as known as ICE, at the Department of Homeland Security since the year 2003. In his capacity as an immigration enforcement officer, he's worked in the criminal alien program for approximately 5 years and has also served as a member of the ICE Fugitive Operations Team. Prior to his service at ICE, Mr. Crane served for 11 years in the United States Marine Corps.
When I last testified before the subcommittee on July 25, 2011, I reported, among other things, that ICE enforcement and removal officers and agents in the field alleged that unwritten directives from ICE headquarters had been issued nationwide ordering officers not to arrest aliens unless it was confirmed that the alien had received a prior conviction for a criminal offense. Aliens who could not be arrested included, but were not limited to, ICE fugitives who had been ordered deported by a federal immigration judge, as well as aliens who had illegally re-entered the United States after deportation, a federal felony. ICE officers and agents also alleged that they were not permitted to arrest or even speak to confirmed or suspected illegal aliens encountered in the field during operations and were prohibited from running standard criminal records checks for wants and warrants. First, I would like to thank Chairman Smith and his staff for working with the union regarding this matter after the July 25th hearing. Chairman Smith provided us with the opportunity to bring officers forward as witnesses. We were also able to turn over several internal ICE documents which appear to not only verify that these activities did in fact take place, but also name several senior-level ICE managers allegedly involved in issuing the directives nationwide. Second, I would like to address the impact and effectiveness of these types of orders. I have never heard of any law enforcement agency in the nation that prohibits its officers from even speaking to or interviewing individuals who are inside a house in which the officers are attempting to effect an arrest. From a law enforcement standpoint, what could be the possible benefit? The only purpose of an order such as this is to prevent officers from making arrests, which ICE leadership has allegedly stated is its goal. However, these directives not only prevent the arrest of non-criminal aliens, but also prevent the identification and arrest of very dangerous criminals, potentially individuals involved in terrorist activities. If not, it not only prevents officers from talking to and arresting persons who may be wanted for crimes, but also individuals who are being victimized and in need of assistance. Certainly, anyone can see that these practices are contrary to effective law enforcement practice and place the public at risk. Many officers will tell you that the majority of their best arrests, the arrests that most benefit public safety, come from unintended encounters with criminal aliens in the course of looking for a different target in the field. Of course, these practices also place our officers at risk. Nothing that I could ever say here today can capture the dynamics as they unfold when a door opens and our officers enter a house that they have never been in before. It's dangerous. Officers don't know who is in the house or what they are capable of doing. Problems often arise that require officers to remain in a house for extended periods. Officers on the scene must have the ability to provide for their own safety. They should never be prohibited from talking to people at the scene, conducting interviews as needed, running appropriate background checks, or even making additional arrests. In terms of better utilizing limited resources, these types of practices clearly do not achieve that goal. As discussed earlier, arrest numbers for serious offenders will fall well below the potential, as ICE prohibitions on speaking to aliens or running criminal records checks in the field will prevent the identification and arrest of many of the most serious offenders. Ordering officers to walk away from and not arrest ICE fugitives and prior deports who have been located in the field is obviously a blatant waste of officer resources and undermines ICE's mission to enforce warrants of deportation and the nation's immigration laws. In conclusion, the inability of ICE officers and agents to perform their duties reaches far beyond the officer allegations that I have cited today. During the last 3 years, ICE officers and agents described what many call a roller coaster of arrest authority that has changed from month to month, week to week, and at times from day to day. Officers, agents, and field managers express concerns that effective law enforcement and public safety have taken a backseat to attempts to satisfy immigrants' advocacy groups. We commend this committee's efforts to bring oversight to the activities of this troubled agency and unconditionally commit our resources to this or any future inquiries made by this honorable body. Thank you for allowing me to speak on behalf of ICE employees. This concludes my testimony, and I will welcome any questions. Thank you.